Recording in progress.
Good morning, honorable members. Good morning. May we start?
Good morning, Chair.
Morning, Nyambose.
It's
morning, Chair.
Nkosi.
Morning. I'm trying to see if the faces are available this morning.
My face is not there, Chair, but this is the Honorable Taibosh. My video is not working, still not.
Okay. Honorable Damas Fago, good morning. Want to see if we've got a forum. Fago, good morning. Honorable Direko, good morning. Honorable Labuskachne, I can't see you.
Morning, sir. I
Van
also
Steen.
see that you can't see me. I'll try and sort it out.
Just say that again. Oh, yes. Good morning. Honorable Van Sail, Honorable Mkhalifi, Honorable Shenge.
Good morning.
Right.
Good morning, Kabazela. I'm here, but my video also is giving me some issues, but it should be sorted. Thank you. Good morning.
No problem. Honorable Sompa. Okay. Good morning. Honorable members, may we take this opportunity to have a silent prayer and meditation. Thank you. We declare this meeting open and welcome all the honorable members who are here. I have not looked through the list properly to see who else is here, but the Honorable the Minister, Deputy Ministers, you're welcome. DGs, you're welcome. And the senior leaders of the COCTA management, you're all welcome. We also welcome the President of SALGA and the leadership of SALGA. In this session, we will have the department and SALGA doing our presentation. So we would like to welcome you all. Do you have any apologies, Shireen?
Good morning, Chairperson, which we do have a few apologies. Honorable Van Zyl won't be attending the meeting as she is busy writing exams. The Minister and the Deputy Ministers will be attending Cabinet, so they won't be able to attend the meeting. The DG will only join us at 10 o'clock, as he's also attending Cabinet, but he'll join us at 10. And then Mr. Lance Joel from SALGA, he will be leaving the meeting early, but Councillor De Vos will be in the meeting for the duration of the meeting. Thank you, Chairperson.
Thank you very much. We note all those apologies. I take it the other members I can't see will be joining us unless they've registered under pseudonyms. But Honorable Mkhaliphi, welcome. Good morning. Morning, you're muted.
Morning, Chair. Morning.
Morning. Thank you very much. So we proceed. Let me then say we want to welcome other members. We've invited various members of provincial legislatures who are involved in the COCTA space. We did that at the request of the Honorable Labus Kahne, but we then opened the invitation to say any other members who you wish to invite are welcome. They have an observer status. They will listen through, but they will not have speaking rights. And if there's anything, they'll have to share their views with the inviters so we can handle the issues as a proper committee meeting. But if there are people from outside the committee, from different provinces, we welcome them. It's really more because the matters here are going to be interesting and also might be very beneficial to the provincial legislatures. And so I think it's a good idea every now and again, when we feel it's important, we could then invite them to come and join us. So we will not introduce them. We just note that they are here to the extent to which they are able to get represented. And so you're welcome as well to you, honorable members from the provinces. We'll then note the apology from SALGA. I hope we'll be able to go through, and then later, when they are excused, we would have had some quite a bit of work covered. Honorable members, we've got two presentations. I'm just struggling in my own mind whether we shouldn't just get the two presentations one after the other, so that we have a comprehensive discussion, because what in effect it means is that the department is going to tell us how they view the section 154 and section 139 or 100 both, the interventions versus support, and then SALGA has to comment on that issue, and then it must then be open for our discussion. So that might give us a pretty lengthy, laborious presentation. But if you can bear with us, I think that might be more helpful. Otherwise, we run a risk of repeating the discussion when SALGA is to come in, whereas we could put everything on the table, especially the SALGA presentation was already seen by the members. We had received an apology from the department that they were busy with a white paper, so they could only submit to us the presentation a bit late. So we note that we did accept the apology. So with the members, I hope we can have an understanding on that in that regard. Having said so, noting the apology of the Minister, Deputy Minister, and the DG, so I'm not sure who's then leading the delegation, but please can you get someone from the department? Dr. Kevin Naidu, welcome. Please go ahead and table the presentation. Thank you.
Thank you very much, Honorable Chairperson, and all honorable members of the committee. Yes, apology for DG. He will be joining us in a bit. Our presentation this morning, Honorable Chair and members, will be shared between myself and Mr. Duma, DDG, responsible for local government operations and support. The purpose of the presentation is to provide an overview to the committee on the difference between Section 154 and 139. And we will do so, Honorable Chair and members, by going through the various aspects of the presentation as we have set it out on the right-hand side. Much of what we will also present is information that resides in the Intergovernmental Monitoring Support and Interventions Bill, a presentation that we had made to the committee a few weeks ago. But in addition to that, we will also be providing information in relation to work that we're doing around support and that we provide to municipalities in various provinces. We start by providing brief introduction in terms of what corporate governance is, a pillar that is embedded in the Constitution, the three spheres of government that we have, and indicate that they are distinctive, interdependent, and interrelated. In relation to its distinctive nature, we note that local government is assigned specific functions and powers. It is interdependent nature, depending on each other to effectively perform their duties, which requires collaboration and coordination. Interrelatedness amongst the three spheres in relation to the interconnectedness and the need for each of the spheres to work together. Of course, you will see in the ensuing slides as well, respect for each other's role being at the center of the distinctiveness, the interdependency, and the interrelatedness. In essence, we say that the Constitution aims to establish a system where local government is empowered to manage its own affairs while also being part of a larger cooperative framework of governance. Now, when we had come here to present the IMSI bill, we had said that much of what we find in the bill is informed by empirical evidence in relation to the support, jurisprudence relating to interventions largely. So we start by saying that one of the things that we found in relation to difficulties by provinces in interpreting what exactly constitutes an executive obligation in terms of the Constitution or legislation, and what powers and functions may be usurped or not during an intervention process. We found that there's a limitation in terms of Section 139 of the Constitution, failure to fulfill an executive obligation, and in many instances led to difficulties in interpreting when an intervention is permitted and what would be the steps that would be permitted in relation to a specific intervention. There's been a vast majority of interventions conducted in terms of general application of Section 1391B of the Constitution, and much less on financial provisions and the issuing of directives. We've also found that there's been little indication that provincial legislatures exercise oversight over the PEC's actions in terms of Section 139 of the Constitution, the inability to submit regular progress reports, including a final closeout report in many instances, the obstructionist tendencies once an intervention is instituted in a municipality, lack of support from personnel, to the extent that there's no cooperation at times, resulting in some instances where destroying of documentation and the issuing of illegal instructions. We've also found that across the provinces, there have been different interpretations or the way in which Section 139 was applied. We proceeded to find that, and perhaps touched on in the previous slide, that municipal personnel are skeptical, reluctant, and uncooperative in assisting the administrator that would be appointed. Provinces were also found to lack capacity to deal with their mandates. And we believe that strongly that some of the interventions could have been prevented if indeed there was an early warning system in place. And as you would note that in the bill, it is now mandatory for the office of in the DPSA to put in place such an early warning system. We found that in some instances, the NCOP had provided objectivity, mediation, and on-site investigation, and we believe that perhaps some of the oversight matters that were found by the NCOP could have also have been matters that could have been dealt with at the provincial level before the NCOP oversight. We found that there's uncertainty regarding the nature of and the required intensity of the intergovernmental checks and balances, disproportionate involvement and support from district municipalities. But key amongst all of this, Honorable Chair and members, we found that participation of the local communities was a critical factor if indeed an intervention needed to succeed. So what is the nature of a Section 154 support? So the ensuing slides will deal with that, with 154 support, and then also 139 support, and we culminate in the differences in terms of these two types of support. We find that in the Constitution, national government and provincial government must support and strengthen the capacity of the municipalities. But what has been delimiting was that there's no clear definition of support in legislation. And it is generally defined as assistance provided or actions taken to help municipalities to meet expectations in terms of their constitutional obligations. We note from the 154 support that we have been providing that it is developmental in nature and not punitive. It focuses on capacity building, and the support can include training, funding, as well as technical assistance. The nature of the support is proactive and preventative in nature. It is to promote effective and sustainable governance. It should be the first line of defense in addressing municipal challenges, but also encourages local autonomy and capability. When we unpack what Section 139 in the Constitution provides for, we break it down in terms of the discretionary nature of the intervention as provided for in Section 139, 1A, B, and C, where A provides for the issuing of a directive, 1391B, assuming the responsibility, and then C, harsher, where it could result in the dissolving of the municipal council. 1392, 1393 deals with processes relating to the interventions. 1394 and 5 are mandatory. The 1394 provides for taking appropriate steps to ensure that the budget or revenue-raising measures are approved, whereas 1395 provides for a municipality as a result of a crisis in its financial affairs is in serious or material breach to provide services or meet its financial commitments. 1396 also then provides for the processes relating to the above mentioned interventions. 1397 is national intervention in the stead of the provincial executive intervening in the affairs of a municipality. And we've seen it in Lekwa, we've seen it in Mangaung, we've seen it in Kajima. When we look at Section 139 interventions, it is a measure of last resort, and it is against the effects of institutional and financial failure, and that support should precede an intervention. It should be invoked at the time when all support plans that have been there have failed to yield desired results, to the extent that the municipality meets the jurisdictional facts for a mandatory intervention. When a municipality cannot or does not fulfill an executive obligation, the provincial executive may intervene. And in the preceding slide, we have indicated, or we've broken down exactly when the different 139 interventions may be applied. But I think importantly, the nature of Section 139, it is reactive and corrective. It is used when municipalities fail to fulfill obligations. It involves the temporary override of the local autonomy of the municipality, and it is subjected to procedural oversight, which is provided by the NPOP and, of course, by the provincial departments as well. This slide basically unpacks and perhaps responds to the question that was posed by the committee in terms of dealing with the nature of sections 154 support and 139 interventions. The nature is supportive in terms of section 154 support, whereas section 139 is more coercive. The purpose of section 154 is to build capacity, provide training as indicated earlier. And then section 139 is to correct failure. The trigger for 154 support is a need for assistance, whereas in section 139, it is non-fulfillment of a duty or duties. The authority derives in terms of section 154 from the national and provincial government as clearly stipulated in the Constitution, whereas in section 139, it is mainly the provincial executive. In terms of 154 support, the autonomy is maintained, whereas in section 139, the autonomy is temporarily overridden. 154 support is more proactive, and whereas section 139 interventions are reactive. But the institution of support and interventions is to ensure that we correct poor service delivery failures affecting communities. Intervening too soon, we believe, undermines democracy, but also failing to intervene allows dysfunction to persist. There needs to, we believe, a balanced, good faith application of both section 154 support as well as section 139 interventions. Honorable Chair and members, these next slides were presented as part of the submission made to the committee when we were providing an overview of the MC bill. I am not going to go into too much of detail. Safe to say that this slide provides the constitutional context for the development of the MC Bill, the various sections from where it derives, but that both sections 100 and 139 gave birth to the MC Bill 103 and 139.8 in particular. We note also that to date, we have 24, or we've had 24 Section 100 interventions, and that 217 Section 139 interventions, with some of them still live to date. This slide provides for the purpose, and it gives it a very high-level overview of the various chapters in the bill. I'm not going to go into it, but you would see in the next slide the structure of the bill. I've starred chapters 4, 5, and 6 because it deals with interventions in municipalities. Chapter 4 dealing with monitoring and support. Chapter 5 dealing with provincial intervention in municipalities. And then Chapter 6 deals with the appointment of the administrator or the national executive representative or the provincial executive representative. So these slides, Honorable Chair, unpacks the various, at a very high level, summarizes the provisions in Chapter 4, 5, and 6. We start, and of course, the provisions in the bill are informed by jurisprudence, by the empirical evidence that we have highlighted at the beginning of the presentation, but also from the 154 support that we have provided, identified certain areas that would need to be provided for in law. To say that Chapter 4, in that municipalities are primarily responsible for fulfilling their obligations as enshrined in the Constitution, that there must be an early warning system, and which is provided for in the Public Administration Management Act. What is needed when requiring support, the role of national and provincial departments in providing guidance, advice, etc. If a province detects a failure or risk of failure in the municipality, the MEC for local government must assess its severity and then, of course, inform the minister of such severity. In implementing the interventions, the minister must consult with the Premier and the MEC and take steps if municipal failure is confirmed. Chapter 5 is more detailed, provides for various decision-making processes, and it provides that MECs may intervene if the municipality fails to fulfill its executive obligations. The interventions can include assistance, directives, assumption of functions, deal with budget-related matters, deal with the dissolution of council, or the appointment of officials. A provincial executive rep could be appointed to fulfill obligations, and he or she could possibly come from government or the private sector. Councils must not obstruct interventions. The provincial executive may also suspend obstructive or negligent officials. The dissolution would require consideration of community impact, something that we've said earlier on is key to a successful intervention, and of course, consultation with national stakeholders. Municipalities must support and not hinder interventions. There's a role to be played by the provincial treasury in consultation with the national treasury in relation to designating alternative accounting officers during an intervention. Interventions must be publicly declared within 14 days and communicated to national and provincial stakeholders. It must be reviewed every 3 months and must be properly assessed and documented with consideration of the impact of dissolving municipal councils. Reviews must be undertaken by the Minister, the NCOP, and other bodies. And municipalities are obliged to provide information to assist with decision-making. Interventions should also include plans for capacity building, and a final report must be submitted within 30 days. Chapter 6 of the bill deals with the publishing of a list for national executive representatives and the provincial executive representatives. And we also indicate that candidates must meet set qualifications and apply accordingly. The roles of the NER or the PER may be fulfilled by individuals or groups acting collectively. The municipal administration would be accountable to the provincial executive rep, while the provincial administration reports to the national executive representative. Dismissed appointees will be removed from the list, and appointees must receive written mandates in terms of reference from the relevant executive. The bill also requires that appointees must report back to the appointing executive on intervention outcomes. The next slides, Honorable Chair and members of the committee, will be presented by DDG Duma, dealing with the status of Section 139 and interventions and Section 154 support. Through you, Honorable Chair, I will hand over to Mr. Duma.
Thank you very much. Please proceed.
Thank you very much, Dr. Naidu. Good morning to the Honorable Chair, the Honorable members of the committee, the colleagues who are in attendance. Chairperson Dr. Naidu has dealt with the theoretical part of the interventions and the Section 154 support. I'm going to attempt briefly to look at the application of these support measures and interventions in municipalities. In this slide, we are just indicating that some of the support that we provide to municipalities is informed by the State of Local Government report, and it is not the only report. The other reports that get compiled that give an indication of the performance of local government, which then precipitates the kind of support that must be provided by ourselves at national as well as provinces. In the next slide, Chairperson, we indicate to you, the members, to the committee, that at the current moment we have more or less 40 the municipalities that are under intervention in terms of the various elements of Section 139. As Dr. Naidu outlined, Section 139 1 is the form of intervention that is implemented by provinces, and so is Section 139.4 and Section 139.5. So these interventions that are outlined in this slide are in terms of all those elements of Section 139. Section 139.7 is implemented by national. And at the current moment, there are 3 interventions that have been involved in terms of Section 139.7, namely Ligwa, Mangaung, and Enoch Gijima. In the next slide, we indicate, Chairperson, the municipalities that are being provided with intensive Section 154 support. because they have been identified in the State of Local Government report as being more distressed than others. There are 38 municipalities that are being provided with that support. But due to the fact that some of these municipalities already have financial recovery plans that would have been instituted in terms of the Section 139.5 interventions. Those financial recovery plans have been used as a method to support these municipalities. So we just want to indicate in this slide which the numbers of municipalities that have the municipal support implementation plans and those that have financial recovery plans in each of the provinces. You will see in the last column of this slide, Chairperson, that we indicate municipalities that do not have MSIPs in place. And what we've been doing over the past few weeks is to work with the relevant provinces to support these municipalities to put these plans in place, because they become the instrument by which support is provided to these municipalities. In the next slide, we indicate, Chairperson, that over and above the two slides that I've spoken to, there is also the Presidential Working Group method, which is being applied in eThekwini and Johannesburg at the current moment. This is done in terms of Section 154, and as Dr. Naidu has indicated, Section 154 mandates both provinces and the national government to support municipalities to execute their functions. And the Presidential Working Group method is intended to strengthen governance and financial sustainability in these municipalities, and to improve service delivery, as well as drive economic growth and the rejuvenation of city hubs and townships. Those are the major main objectives of the Presidential Working Group. There may be other objectives that are being pursued at an implementation level, Chairperson. For now, this method is only applied to metros, but that is not to say that it cannot apply in other metros, in other municipalities. In the next slide, Chairperson, we indicate that in August 2024, Cabinet had taken a decision to establish an IMC on municipal performance and turnaround strategy. This was pursuant to the presentation that was made by the AG to Cabinet, indicating the extent to which municipalities have been poorly performing in relation to their financial and non-financial indicators. So Cabinet had taken that decision, and the IMC is chaired by our minister, the Minister of Cooperative, and the IMC had decided to start with 10 most distressed municipalities, which are listed in this slide. And the focus is on trying to turn around these municipalities. There was extend this list, but that is being processed at the moment. In the next slide, Chairperson, we indicate that over and above all these instruments is
sound, or is it only for me?
about 2 weeks, achieve the four objectives that are listed there, which are the reforms in particularly in the trading services in municipalities, and the review of the local government white paper, the review of the local government fiscal framework, as well as the professionalization of local government. In terms of the first objective, we indicate that National Treasury has already commenced with these reforms and in the 8 metros across the country. And they have done quite a extensive work in trying to ensure that the trading services in municipalities are run as ring-fenced entities that can make surplus, or in cases where they incur deficits, and municipalities are able to attend to those. In the next slides, Chairperson, we that are in Annexure B. I'm not going to go through them, but they outline the instruments that government uses to support municipalities. Particularly, you will see, if you go down, you will see that we outline there, or we give an indication of the fact that, go down, please. Yes, up to, yes, go next one. Yeah, we indicate here that we are supporting municipalities in respect of electricity and energy. In the next slide, we indicate that the support is also provided in relation to the water and sanitation, particularly in response to the blue drop, green drop, and no drop assessments that were conducted, or that are conducted by the Department of Water and Sanitation. In the next slide, we indicate that over and above that, we are implementing what we refer to as Schedule 6B in 21 municipalities, where we're supporting them to fix particularly wastewater treatment works that have been found to be dysfunctional and are polluting water systems across the country. In the next slide, quickly, we indicate that the Department of Water and Sanitation dispenses this type of grant to water services authorities, some water services authorities, to support in relation to water, bulk water infrastructure. In the next slide, we also indicate that the same department also dispenses another form of grant to support municipalities in relation to water systems. In the next slide, we indicate the support that we are giving through the MIG, which in the next slide, you will see that we indicate that support cuts across water and sanitation, roads and stormwater management, solid waste management, as well as recreation facilities. In the next slide, we indicate that there's another instrument which we call Integrated Urban Development Grant, which we also use in some municipalities. There are about 10 at this stage that receive this form of grant, but they also use it for water and sanitation, roads and stormwater, waste management, public facilities, and electrification. In the next slide, we indicate that there is another instrument which is dispensed by the Department of Human Settlements, which targets metros. It's called USDG, which they use for a variety of services that are listed there. Chairperson, I think we are going to stop here, but this was just to indicate that through Section 154 and Section 139, these are the kinds of support measures that are in place that are being applied by government across the board in these municipalities. I'm going to return to Dr. Naidu, who's going to conclude the presentation. Thank you, Chair.
Thank you very much, Mr. Duma.
All right. Thank you very much, Mr. Duma. As we hand over back to you, Honorable Chairperson and members of the committee, we thank you for your attention.
So you're done. So Naidu. Okay, thank you, Dr. Naidu. Let's proceed then and request SALGA to take us through their presentation, and then we'll have questions and discussions afterwards. From SALGA.
Good morning, Chairperson. My name is Dion de Vos. I'm a councillor and a NCOP rep of SALGA in the council provinces. Our presentation will be presented by Mr. Lance Jewell. We appreciate the opportunity to also present on this very important matter and the invite of this committee. Without wasting time, I will immediately hand over to Mr. Lance Jewell to make the presentation from SALGA. Thanks again.
Thank you very much, Councillor Joel. Let's have the presentation. Please proceed.
Well, thank you very much, Chairperson, and also extending greetings to yourself, as well as all members of the Portfolio Committee, and all the invited guests, the leadership of COPTA that is in the room. Greetings. Chairperson, I am going to make the presentation as a SALGA perspective. I would want to indicate upfront that there are a number of issues that has specifically been raised by the team COPTA that would also resonate with some of the issues that we are raising, and certainly it paints a picture that as those that are playing in the local government space, we are starting to have common views about what is going wrong, what is going right as it relates to both Section 154 support, but also in particular the implementation of Section 139 of the Constitution. We will make specific examples, Chairperson, where we feel as organized local government that certainly things could have been done better. And the unpacking of the examples will detail what those areas are. So from where we are sitting, there are three key legislative and policy drivers that informs support to be directed to municipalities. And Section 154, which was extensively referred to in the previous presentation, is one of those. Secondly, when we look at the National Development Plan, it likewise also provides for support to be directed to local government through a number of measures, and it is detailed there on the slide. And then lastly, when we look at the two-tier system in local government, district versus local municipalities, there is also an obligation placed in particular on district municipalities to provide support to the local municipalities that are within their particular district itself. So within local government itself, there is a specific provision for support. And then between the three spheres of government as directed by the Constitution, there is support to become from national and provincial government. This slide is a reflection of since democratic local government in 2000. What have been the national support interventions that have been directed to municipalities? And you can see that, Chairperson, there are a number of national interventions that have been directed at local government. And when we have an unpacking of the successes or otherwise of these respective national support plans, we reach a conclusion as SALGA that there is very little positive developments that unfolded around these national support interventions when we compare it with the resources that were directed towards local government. So the question that we certainly as SALGA pose is, are these type of support interventions appropriately packaged to respond to the needs at the local government level, such that it can be of high impact, such that it can turn around the tide within the local government space? Of course, acknowledging, particularly from a SALGA side, that there is much to be done to turn around the current form and shape and impact of local government itself. When and what the slide does, it really just unpacks what I've said earlier. For us, we believe that despite these national support interventions, we do have existing initiatives that could be, existing mechanisms that could be used by government, whether nationally or provincially, to direct support to local government. And typical examples of those are the Section 71 and Section 72 reports that are required in terms of the Municipal Finance Management Act, but also the Section 46 report that are required at the provincial level through the Municipal Systems Act itself. These are reports that paint a picture on the state of affairs, financial and otherwise, within municipalities, but they are not, in our view, used effectively, and they're underexploited for purposes of assessing on an ongoing basis the state of local government, more particularly the state of particular municipalities. And in our view, these reports present opportunities to determine whether there are governance constraints in municipalities or whether there are financial constraints that are on the horizon, but yet they are not being used. And we believe that through their use, an early warning system could be developed that would be able to respond decisively and timelessly to issues that would be emerging based on the pictures to be painted by these reports. We also want to emphasize the point that was made in the Cooperative presentation, that we agreed that perhaps at both national and provincial level, they are not appropriately equipped and or capacitated to direct impactful support to local government itself. And that's a weakness we think should indeed be addressed prior to wanting to direct support to local government. I am not going to go through the next two slides, Chairperson, because the Cooperative presentation indeed detailed the opportunities presented by Section 139 to intervene in the municipalities. I'm not going to repeat what has been presented by Cooperative itself. From a SALGA perspective, because quite often, Chairperson, the question is asked to SALGA, where are you? what is your role when it comes to interventions itself? Now, when we look at the Constitution, Section 139 in particular, Section 154 in particular, there are no specific roles and responsibilities allocated to SALGA when it comes to interventions. At best, when we deal with interventions in terms of the Municipal Finance Management Act, where there's a financial crisis in municipalities, there is a defined role for SALGA itself. And then firstly, the role would be where a financial recovery plan has been developed, and we've been consulted together with the municipality on that financial recovery plan. Secondly, that as the intervention unfolds and reports are developed, the quarterly progress reports are to be submitted to SALGA so that we can also get a first-hand picture of what is the progress that is being made. And then lastly, when the NCOP post a decision taken by the Executive Council in a province to intervene through Section 139, we have an opportunity as members of the NCOP to make representations, whether we would support it or whether we don't support such an intervention. And that's really the role that we play as organized local government when it comes to interventions. And when we ourselves, Chairperson, because we also are mindful of the reality that SALGA has both a national and a provincial footprint. The provincial associations are much closer to the action, but also may at times be influenced by the local provincial politics in that setting. We are not generalizing the point, we are making it a point as a risk that would find expression. And so what we have done is that at the core of us considering our approach on interventions, we have sought to answer these questions. And for us, SALGA, the position is that any intervention should be seeking for local government to achieve their objects as defined in the Constitution. And those objects are listed on the slide. So the questions we would be asking is, will this intervention, when it takes effect, will it advance the provision of democratic and accountable government for the people in that municipality? Will it advance the provision of services and the sustainability of those services? Will it advance the promotion of social and economic development? Will it advance the promotion of a safe and healthy environment? And lastly, will it improve the involvement of communities and community-based organizations within that particular municipality? And the answers to this will then indicate whether that intervention is in fact necessary, or we ought to be looking at alternatives to respond to the challenges that are being faced by that particular municipality. And we want to give you specific examples, as I've said, Chairperson and members of the committee, of where we had been very involved, where decisions have been taken around interventions in municipalities. And we have chosen two, and there's a third one that we've added, to three, and a fourth one that we've added, to just give you a picture that will indicate to you the difficulties we as organized local government face around interventions. And the first example is that of the city of Tshwane, where a decision was taken to intervene in that municipality by dissolving the council. All we should indicate, and it's really linked to SALGA's involvement constitutionally in interventions, is that when that decision was taken, we were not consulted. We were not engaged prior to the decision taken to dissolve the city of Tshwane. And when we were informed of that, we were then attempting to deal with both the municipality as our member, but also with the relevant MEC at the time, to try and understand things better and what informs this decision. So as they emerged, we were not aware of these things. and we had to engage with the relevant players. And as we engaged and were able to get information, we had to apply what we have agreed as SALGA would be our test in assessing the need for an intervention in a municipality. And we've done exactly that in line with the object of local government. And those were the questions. I'm not going to repeat them, Chairperson, similar to what I presented a slide or two before. And we reached a different conclusion. In fact, we felt quite strongly in applying this test that this intervention would not to advance the objects of local government. In fact, we had felt that the real solution to the problems related to what needs to be done within the city of Tshwane. There were 5 things that needed urgent attention. That was an election of an executive mayor, the appointment by the executive mayor of members of the mayoral committee. The position of the city manager has been vacant. We thought in order to introduce stability in the administration, at least, a city manager should be appointed. The city of Tshwane at the time was not had not established the work committees. We thought that was a necessary mechanism to engage with communities and being alive to the realities that communities are dealing with. And then lastly, we also felt that the council for a sustained period of 9 months has not been able to execute their real function. The focus in the main for the 9-month period has been about motions of progress. And so we felt that the solution to the problems resided in council, in the municipal council itself. And we felt that in all 5 of these respects, the council was at the center and could be part of the solution. And we felt attempts should have been made to ensure that this council itself plays its role as is required by the legislation. Well, unfortunately, the reality is that there was not a common agreement with the SALGA views, at least as the matter was being processed, including in the MCOP. We were very concerned at the time that because an election was going to, a by-election was going to have to be convened within 90 days, and we were in a national state of disaster at the time, that it would not have been possible to convene the by-elections. And therefore, there would have been a difficulty in complying with the Constitution of the Republic. Secondly, we felt that because the problem resides in council, and others felt that council is the problem, therefore let's remove the council. We had a very strong view that when you go to the by-elections, you may just return with a majority of the same councillors. Post a by-election, it still sit with the same problems. And we have seen that, the Chairperson, in many other instances where municipal councils were dissolved, they went for a by-election, and the majority of the councillors were dissolved and returned to office. We felt that would have been the same risk facing the city of Tshwane at the time. Be that as it may, we all know now what has happened. The intervention was agreed to despite our concerns as SALGA. The matter was then challenged in court. It was successfully challenged in court. It was appealed. The appeal itself was unsuccessful, and the councillors were reinstated. And what we saw following in the months thereafter is that council now to be reminded what their responsibilities are by a court. So the court had said that, and we want to just draw your attention, Chairperson, some of the things we felt were in that court judgment that we felt did not need the court, but unfortunately, that's what happened in the instance. The first point the court was making is that the running of the city by an unelected administrator is the very essence of um, going against the values of that particular democratic and accountable government for communities. Secondly, the court said to us, the citizens of the city of Tshwane have a fundamental constitutional right to be governed by those they elect. So the court had serious concerns that the elected leadership of Tshwane was removed, make way for an unelected administrator, disregarding what the electorate had dictated. So the outcome of an election should be their leaders at the local government level. But also, the court had to say that irreparable harm have been established, not only by the applicants, but also by the citizens of the city of Tshwane. So that decision itself to dissolve were really against the needs of the city of Tshwane. And that's what the court ultimately directed us. The court went further. We are not highlighting this now, the chairperson, but we perhaps want to indicate this. The court went further by saying that the most important responsibility of a councillor is to be in a council meeting and remain in attendance of a council. That court judgment has led to the changes that we've now introduced through COCTA, engaging with Parliament, and then making amendments to the Structures Act, but also in issuing regulations on the Code of Conduct. That is now outlawing councillors leaving council meetings or councillors not attending council meetings. And it's unfortunate that Chairperson remembers that the court had to do that when, in fact, as SALGA, we were quite upfront during the NCOP processes by saying the problem resides in the municipal council. And the solution, therefore, is also in the same entity called the municipal council. And there was a need for us to ensure that the municipal council gets to execute their responsibilities as is required. So that's what unfolded in the Tshwane matter. Mfuleni, the chairperson, we are raising the Mfuleni matter because we were intricately involved in the initial and the second extended intervention in Mfuleni. And during that time, we had raised a number of concerns, and we had felt that for a number of reasons, the appropriateness of the intervention in Mfuleni has had its weaknesses. We were quite clear about those weaknesses. We were not supporting an extension of the intervention in Mfuleni. It is now water under the bridge, Chairperson, because once more at the time, we had felt that the difficulties of Mfuleni were informed by the interventions themselves. That we can reflect now on since then what has happened in that municipality. Under the guidance of an intervention, under the guidance of support, that municipality continues to struggle. It continues to struggle, and we are now 7 years later since the extension of that intervention in that municipality. Of course, Chairperson, we also, through our engagement, because what we ordinarily do is that we also interact with the municipality itself. We also interact with the MEC for local government. And at times, we want to reaffirm the point that is made by COCTA in the presentation, that there may be an argument to be advanced that to some extent the municipal councils themselves to also contribute to non-improvement during the intervention phase itself. That's an area that we really need to address head on. That's a conversation we want to, as SALGA, continuously have with our municipalities that would ensure that where there is support directed to municipalities, that municipalities must welcome this, must collaborate with those that are sent to provide support to municipalities, must accept the assistance that is directed by national and provincial government, so that we do see improvement in those municipalities. So I thought we should raise that issue, Chairperson, because it reaffirms the point that is made by the department in the presentation. The next intervention, Chairperson, which is we would want to reflect on, is Mangaung. I think everyone is aware that Mangaung itself was also subjected to Section 1395, which is the financial turnaround intervention in that municipality. There were a number of processes that were followed, which we felt had weaknesses or procedural weaknesses found expression during that intervention that we had raised at the time. Substantive weaknesses arose leading up to the intervention, during the intervention itself, that we would want to raise as SALGA. And we also felt that in many instances, provincial and national government were not assisting this municipality to improve. And the jury is out there. Of course, whilst we are excited that we have seen in recent times, Mangaung starting to getting his head above the water, that's a positive development. We remain concerned that this will be a sustained outlook for that particular municipality. The last municipality we will touch on, I'm trying to skip many of these slides because I think the central points have been made, is around Ditsobotla itself. We did not put slides, Chairperson, but we are going to make the point. When Ditsobotla was first dissolved, we took the very same stance as we took during Tshwane, that the solution was not the solution to the challenges of Ditsobotla. The challenges of Ditsobotla lied elsewhere. And what happened? Once the municipality was dissolved, they went for a by-election. And what did the by-election bring back? A majority of the people that were there were dissolved, returned to office. In fact, we have not seen an improvement in that municipality since it was dissolved. And now we are once more having conversations about should there be a dissolution of the Ditsobotla once more. So the point we want to make is that as SALGA, we do feel that Section 139 is used in instances where it is not the solution to the problem. The solution to the problem lies elsewhere. We are not tapping into that solution. That's the same difficulty we think Ditsobotla itself is currently experiencing. Similar to what COPA is providing, Chairperson, perhaps I don't even have to present this part. As SALGA, we believe that the IMSI bill, in its current form and shape, will aggressively respond to the challenges around not only Section 129 implementation, but also Section 154. And it is very aligned to what is on this slide. So perhaps because the portfolio committee has had the benefit of being exposed to the IMSI bill, is that we do believe that it is a positive development and we will support it in its current form and shape, as we believe it will contribute towards a bit more stability in the local government space through either support to be directed by provincial and national government, or where there's a real need for intervention, that it is indeed a intervention that is appropriately guided through the framework in the bill itself. And the chairperson, that is our presentation. Thank you very much.
Thank you very much, Mr. Lance Joel. Mr. Councillor De Vos, do you wish to add anything?
No, Honourable Chairperson, thank you very much for the opportunity. I think Mr. Lance has represented the views of SALGA very successfully, and we appreciate the process of the formulation of this bill, because we do believe it will attend to many of the things SALGA has been confronted and faced with in the issue of interventions. Thank you very much, Honourable Chairperson.
Thank you very much, Councillor De Vos. Mr. Lance Joel, just come back. My reception is a bit poor, so some of the words from your side were cracking, so I missed something. Do you say you are happy with the IMSI bill? Do you support it? It will do what it's designed to do? Just the statement. What did you say? I didn't quite get that from the cracking sound.
No, apologies for that, Chairperson. I hope that that my reception is not on my end. Firstly, Chairperson, when the bill was drafted, we were given an opportunity as SALGA to make our contributions to the bill. At the time already, we had felt that it is an appropriate response to what we believe are the core challenges around not only Section 139, but also Section 154, as it is directed, supported as it is directed to local government. So there is a general support on the part of SALGA, because we do believe that it is a solution driven. Thanks, President.
Okay, thank you. Now I'm asking that because amongst your early opening slides, maybe your main slide at the beginning says early warning systems are already built into the support process, and that but they are not used effectively and are severely underexploited. Now, there are other opportunities presented, but there need to be some actions. Opportunities must be utilized before problems escalate. So with that slide, I wanted just to understand where you are as SALGA. But if you say that statement is now solved by IMSI bill, then I understand what you're saying. But is that what you're saying?
Honorable Chairperson, exactly that. Maybe to take it further, what we believe the IMSI bill does, which currently, because we have the Section 71 and Section 72 reports that are not used effectively, what the IMSI bill does, it now crafts an appropriate guiding document, or it provides guidance then in specific detail to provinces, to national, on what should be done prior to intervening. And early warning systems are effectively entrenched in the IMSI bill itself. So we do believe the bill is the response to that weakness that we are raising in the form of a guide. Thanks, Chair.
Okay, no, that's fine then, because that was, for me, the main issue is you are seeing problems at the start, just to be sure that you're no longer worried about those when we get to the fact that there's a bill now in place. Now that's fine. Otherwise, I was going to be asking the department to respond to this slide if your concerns were still unaddressed despite the IMSI bill. That's at this point, then I think it allows us space now to get the honorable members to ask questions and make comments based on the presentations and the response of SALGA. Honorable members, the matter is now open for discussion. I have received the apology from Honorable Sompa Masiu, who is unwell and will therefore not be part of the meeting. We did acknowledge the Honorable Honorable Van Zyl, and we wish her everything of the best in her exam. In the meantime, honorable members, are we comfortable with the presentations as they explain the two issues, the general support based on Section 154 and the intervention of the higher sphere at provincial based on 139, at a national based on Section 100, and that the lacuna or the gap in the application between constitution and action on the ground has been addressed by the IMSI bill that deals with the gaps where there were differences of interpretation, effectiveness in the intervention, appropriateness of the instruments for intervention, and the processes that need to be undertaken to decide at the point at which the interventions are needed and to define clearly the support from the sphere above in terms of how Section 154 then gets conducted, and how this IMSI bill will eliminate the misunderstanding and often the conflicts or contestation over roles and authorities between the provincial and municipal spheres, so that we do not end up with court cases as has been described in this instance. Are we then comfortable that that's where we are? Because if we are comfortable, that ends our discussion. But if there are any concerns, then from the members, since there are no hands, I'm going to ask each member.
Chair, I've raised. There are a lot of hands.
Our hands are there, Chair. It's Mkalipi, Zwelake, Lapuskache, Taibosh.
They have hands?
Yes.
Yes.
Oh, yes, my computer wasn't showing these hands. I'm sorry. Now I can see the hands. Oh, my apologies. There was some problem here. So Honorable Mkalipi, then followed by Mtetwa, Honorable Labuskaghne, Taibosh, Sompa Masiu is back now, and then Honorable Direko. There we are. And then Honorable Buthelezi. So there we are. Let's proceed, Honorable Mkalipi. I'm sorry about that. There was a problem with my laptop.
No, thanks very much, Chair. That's why we must meet physically when we deal with this important subject, Chair.
No, we must simply sort out my laptop so it doesn't give you confusion. We don't have to meet physically.
Oh, we do, Chair. Even the presentation by Lance was not clear, as you also alluded to that fact, Chair. Chair, thanks very much for the opportunity. Yes, indeed, the two presentation is also cover some part of the concerns. I know, Chair, we have been pushing for IMSA bill as the committee to come and will be a solution to our many problems, but it's not going to be the total solution. If you listen to SALGA, CEO Lens, saying that one of the challenges one of their views, as he put it through the problem statement, is that there was no consultation in some of the matters regarding Tshwane municipality. So IMSA bill is not going to cover that. It also has to talk to the early warning systems, which I think SALGA also emphasized on it and the department emphasized on it. So therefore, Chair, my question, are we really having tools of dictating through the early warning systems? Because we cannot be continuing as the department, as the portfolio committee, as everyone, all stakeholders, to be fire extinguished. We can't continue like that, to wait until there's too much or huge damages. And then we said, no, come and apply Section 139 or come and apply Section 154. So I want both SALGA and the department to tell us, do they have a capacity to apply early warning systems to all these municipalities? The report suggested that, as the DDG Kevin Naidu's presentation suggests, that in totally, there are 40 municipalities that are under administration or under Section 139. But the fact of the matter, all municipalities are sick, Chairperson. There are symptoms. And I always argue this point, even the last time when the Deputy President was here in the House, to say that under Uvulindlela program, they have identified 10 municipalities out of 66. I also made an example of eThekwini. It's not part of distressed municipality or dysfunctional municipality, but they are under presidential working group because there is a challenge in regards to their finance affairs. So I'm saying, is the department have a capacity to dictate all the problems that are happening in the municipality? The second thing that I want to raise, Chair, right there on the presentation by the department, under empirical evidence in administration of interventions. So one of the things that is bullet point 2, limitation of Section 139, subsection 1, the failures to fulfill an executive application led to difficulties in interpreting A, when intervention is permitted, B, what steps are permitted. So those are the things that we need also to be told by the department. These are the things that we are facing. We can't interpret the provinces, they can't interpret what Section 39 is saying in details. So therefore, as the department, these are the things that we think it can help us to interpret such Section 139 or Section 154. But if we are also struggling with the role of the province and MEC also can't interpret, it's also going to be a problem for a longest time, Chairperson. For instance, the president of SALGA is also a speaker in one of the municipalities in Machabeng in Free State. The court, there's a court case in that regard that this municipality must be put under Section 139. So therefore, the MEC wrote a letter to the speaker, which is the president of SALGA, and said, please convene a special council so we can communicate about this Section 139 that needs to happen. The speaker also wrote back to the MEC and said, no, I can't, because the rules of a municipality does not permit me as a speaker. So I was hoping that the president is going to be here, because if SALGA is also saying, please involve us in earlier point in order for us to have a say and to also to advise you. And then now there's this situation of rules in the council that also cited by the speaker of the council to say, no, don't come to me as a speaker. In terms of the rules of the council, I'm not permitted. Those are the issues that we need to vested with as portfolio committee and the department to tell us, okay, when do the legal advisors of the department comes in order to solve these problems? The IMSA bill, Chair, is also going into details about the role of the administrators in the council. So we know also that in terms of Section 139 of a constitution, the administrators are not the solution in all cases. And the department will agree with me to say, in all these 40 municipalities that the department said they are under administration, I even made an example last time when we engaged with IMSA bill to say that, but we must also have a clear report, a clear monitoring system, and an update in terms of those administrators that are put by the department are also helping the situation or not. Because most of the time are not, Chairperson. And I'm very happy because some of the reports between the SALGA and the department presentation also made it very clear that we have this thing called solutions in a form of administrators, but at the end of the day, we have more problems than what we anticipated. When we went to Liqua, I even made that example last time. We even asked the department when he was presenting and telling us that, no, we still have an administrator. We asked a simple question. We're just coming from elections now. It was after 2021 local elections. And we are still saying this municipality who went and elect the new leadership in these councils is under administration. How does it work? Because freshly, these people are assuming the office. They are going to ask you, why are we under administration? Because we just elected Izolo. Yes, just yesterday. So the department couldn't also clarify that point to us to say, no, they are still under administration, because when we apply or when we send the administrator here in this municipality, it was for this period. So therefore, the period is still continuing. So those are the issues that I think is basic, Chair, in order to get it right, in order for us to have a way forward in terms of addressing these issues of municipalities. The other challenge is that, and I'm very happy that it's also finding resonate in one of the presentation, I think is SALGA, to say, are we sending right people with the right skills as administrators? And the committee will remember very well, there was an issue that was raised to say that one of the administrators who happened to be in the Gauteng municipality or Gauteng provincial office was not even having a matric. And that administrator was sent to Northern Cape to be the administrator there. And people were up in arms that you can't send a person who does not have a matric, who frauded matric in Gauteng. And then you send him here to do what? Because that person who's lacking matric, who have a record of defrauding even his qualifications, those are the problems that we need to talk frankly. I'm happy, Chair, that you are having this kind of a meeting after the launch of the white paper, whereby the stakeholders, even the people who are on the panel, were saying, what went wrong? How do we fix it? Because even the IMSA bill that you are also pinning our hopes to is not going to be our solution until we get it right from the department level, and also the role of the provincial government. I still debate that. I think at some point, the role of the provincial government, or especially COGTA, it must be questionable, it must be clarified, because some of the issues we tend to say to the department, please tell us as the department, are you ready through your program 2, which is the intervention? But we forgot there is also COGTA at the provincial level who need to play their role as well in order to make it sure that these municipalities are also in the right direction. Thanks, Chair. Those are my contribution for now.
Thank you, Honorable Mtetwa.
Greetings, Chair, and greetings to fellow honorable members, and greetings to departmental officials and any other leadership which we are told will be joining us later. I'm gonna address myself under a topic which in public management is called the environment of a public manager, which is highly regulated. And this public manager we find at national, provincial, and at local government level. This is where we are having a paradox of legislation, which must be applied by a public manager in executing their function. National, these are now spheres of government. National makes policies, province makes provincial ordinances, local government makes local government bylaws. This is where we got it mixed up. By allowing national and province to go into elections, we are sending a message to say national and province are one and are actually rotating under one cycle of election. But when you come to local government, they are rotating at a different cycle and period of their own election, which then makes them independent and distinct, yet in terms of applications and laws, we are seeing these sections we are quoting here, section 154, it talks about national helping local to execute their function. Two, the issue of finance, it is emanating from national through province to local. And yet, it is saying execution of their own function. So which means when it comes to function, it is a local government baby. When it comes into support, it comes from national. Then the question stands, who will prevail in what point? Because on one hand, you are helped by national. On the other hand, you are prevailing based on a constitutional mandate, which then when you deem it fit, you decide to declare independence from national and province, which is in the constitution, which is in the laws, which wherein you are operating. That is one. Another point, when we talk about intergovernmental relations, monitoring and support, the question that stands, it can't be that the one who issues support for the other, which is local government, can also be the one who troubleshoots the problems at local government level, because those problems are emanating based on their legislative function, wherein national and province have no jurisdiction, but we are relying on intergovernmental relations that it will help us. But if intergovernmental relations is not legalized as a function, as the cracking of the whip over local government, either by national or province, then you have also a deadlock. Because in the tiers of government principle, you have legislature, executive, and judiciary, which they are all independent and they execute their function. So in this case, when we reach a deadlock, we need somebody to stand in, but it can't be the same person who is coming to crack the whip on the same people that you are supposed to give support to, and you didn't give enough or sufficient support according to local government. Then it shows that there was a gray area where national didn't execute their function and where also local didn't execute their function. And that gray area is where we are finding ourselves in. And I'm happy that actually my colleague is also mentioning the issue of the review of the local government white paper, because it has given us a 27 years of perspective and review of things that didn't go right. I can single out one aspect, which is a problem child of local government, but it was defined out of the environment of local government and government, the institutional arrangement, the issue of Amakosi. I listened yesterday, over 27 years, there was no mention of anything about Amakosi because they were defined outside the local government white paper in terms of them having powers to participate. Now they are bringing a bouquet of problems into the local government, but the choices of policies that we decided to take, they've defined an institution of Amakosi outside the institutional arrangement, which then led into problems that are escalating for local government. So local government has to babysit issue Amakosi, but Amakosi should be defined at constitutional level. And then you come at white paper on local government level, which is non-existent in this case. And I can tell you that most of the problems that are inherited by local government, it is that backlog of Amakosi that were never in that sphere, and now they need to be serviced, and we cannot extend services to them because they are not contributing financially. They are also not defined legislatively in a manner that allows you to do anything that you deem fit. These are the problems that we have created. Also, we have seen that we are sitting with over 40 legislations that must be done by local government. Yet, you are already executing a mandate that comes from national by virtue of the monies that they are dispersing at local government level. The question is, why do you still expect local government to make bylaws? Because by virtue of making bylaws, you are saying we are not necessarily implementing national and provincial government power policies, but we're also sitting to define our own bylaws, which sometimes contradict the national and province. And also this is exacerbated by the fact that we are rotating at different cycles of elections. So it means when you see local government working, they are not necessarily executing a mandate of the national and province, because it is the other cycle of a duration, and so it's overlapping. It's not working actually seamlessly or synchronized. So these are issues we need to figure out. But I see also another legislation that is a problem to local government. The Mineral Resources and Petroleum Development Act is a national policy which must be executed at a local level, but you find that local government has no jurisdiction to engage on issues of minerals and energy. Now, which means they must be deferred to national. And once you do that, you are abdicating a responsibility where you are expected to deliver energy and electricity to your constituency, yet you don't have powers to decide on those at a legislative level. It brings you problems. Another problem, a policy position that we've taken, which is contradicting, it is the economic policy environment. We find ourselves in a monopoly in South Africa whereby the economy is not even in the hands of the state. So the state cannot make expressions and say we must grow the economy because they know they don't control the economy. Another problem we created, we have privatized the economic environment and the economic drivers, which then also limits the intervention of the state, because now you're dealing with private sector who are operating differently from a public sector. And that is a clash of a public versus private environment, and wherein those who control the economy, they are dictating terms to government, and then government is now on a receiving end of what private sector is saying. If you don't listen to private sector, they collapse the economy, they stagnate the economy, they take their money elsewhere, and they threaten you. You end up having to listen to an external agent, whereas you're supposed to fulfill a national mandate. These are also issues that we are facing ourselves in. Also, in this period of the white paper on local government, I know that we are dealing with a backlog of forced removals. Local government suffered a lot during the Forced Removal Act. And then the perfection that we are told, which existed before the democratic dispensation, was achieved at the expense of forcibly removing Black communities from prime lands where economy was being generated. Today we're sitting with a backlog of those forced removal communities, and there is no forced restoration of those forcibly removed communities back into economic mainstream. As a result, they are viewed as a problem or as a sore eye of local government, but they were created by a legislation. Then also another problem, the Roman, Dutch, and British law is throwing a spanner in the works, because when you have to deal with issues of amakosi, you then have to use a Roman, Dutch, and British law principles, which are contradictory to the native laws of amakosi. Then it means you have a deadlock again, because you cannot interpret some cultural heritage issues of the natives using a foreign law in a foreign land that is null and void. So you have to deal with issues of jurisdiction, which is a problem. So the case of Richards Bay, where amakosi took to court a private sector company, it actually introduced problems for umasipala was Richards Bay, wherein now they have to manage a situation where an institution that is defined outside local government is now causing problems for the institution of local government, but which it is in their right to defend their land, but the state is nowhere to be found in terms of how do you handle this matter. It is because of the policy choices that we took, which was mentioned by the president of SALGA. So the case we are
Honorable Mtetwa, you should round up, please.
So the problems we're addressing is a parent and a child relationship where national give money to a child, which is local government, but it's saying go run your show. But when there are problems, national must come and intervene. But at the same time, this child is having rights to say, I can do what I want to do, and which leads to the service delivery being affected. So we have a conundrum, and this conundrum is caused by powers, positions, and principles, and administrators. You cannot have an administrator who is going to manage an institution which is actually governed by elections, but when there are problems, you invite an individual just based on his expertise. It doesn't work like that. So we must create powers, positions, and principles to manage everyone, but those cannot function internally, in which it could be an external force so as to hold everyone accountable. Unfortunately, we don't have that kind of arrangement. Thank you.
Thank you very much. Let's have Honorable Labuskaghni.
Thank you very much, Chair. Good morning to everyone, and thank you very much for the presentation today. Chair, I've got quite a few things that I would want to comment on and or ask questions. I'm going to start off with the empirical evidence that has been raised, discussed by COPTA, which I think we all agree with. The findings, when is intervention permitted and what steps, and the proposal of early warning systems, which I agree with. I would like further on to say that I think all these evidence are we are going to try and address that in the IMSI bill, and I haven't studied that bill to the T, but I also want to say and agree with the SALGA presentation that even if there is early warning systems, and I will get to that later on again as well, the Section 139 interventions, the start, when it should start, should be based on terms of reference spelled out, based on the early warning systems. Otherwise, it's not going to help us. And then I think we have a big discussion, as one of my other colleagues already mentioned as well, on what is the oversight, or why, and what is the reasons, and the capacity has been indicated, but a real deep discussion on the oversight role of the province, not only for the IMSI bill, but I think, as we've also learned yesterday at the launch of the white paper, because I think that will strengthen or weaken the whole total system of local government and government in at all. The early warning systems, my question at this stage is, what is the consequence if it's ignored? And we can have long discussions about the intergovernmental relations and the cooperative nature of relations and a separate sphere of government and dependence versus independence. But the bottom line is, whatever is going wrong in governance, and specifically on a local level, impacts on people's lives, on the residents living in that local government, whether it's political, whether it's a failure of systems, whether it's skills and the incapacity, whether it's political, whatever. And we can have highfalutin disagreements and discussions, but what the things that's not happening, and whether we interfere from one level to another level or not, will have a basic influence on the people living in each and every town. And we will have to address that, because we say, and our chapter 2 of our constitution says that we want to make this country a place where we address every need and every right of all people and make it a good place to live. But then we have fights about who is the boss and who has the power. then the nature of the 154 support, I'm very, very thankful that we had this presentation today, Chair, because it brings a bigger, the big picture for us. And I would like to know, and it came out in some places it has been referred to, but is there a standing operation procedure? Is there a system in which these sort of support initiatives from either provincial, because this is where it should start, from the provincial level to the local government, and from the national level to provincial level, and say this is the operational, this is how to go about to get support if you need support, or this is how we're going to go about to make sure that all these things are working, and if they don't need our support. I think for ourselves and in the white paper, we need to unpack effective and sustainable governance, because I think there is a lot of different definitions and understandings of that. And then on that slide, the mode of interventions has been clearly spelled out by the department, which is absolutely correct on what is discretionary and what is mandatory. And as being demonstrated by the SALGA case studies, unfortunately, is not working like that at the moment. And I'm not so sure that that the embassy bill will definitely sort this out, because it's to the discretion and the understanding of a COCTA minister on what is a executive obligation. So if those terms, that is like an executive obligation, and what specifically is support, if those terms are not described as definitions in the embassy bill, we will still struggle with the understanding of this. And specifically, the one thing that is at this moment a big issue is that administrators are being appointed in municipalities even if a municipality is not dissolved. If we understand this, and it's not coming, it wasn't clear in the presentation, but my understanding, and maybe we can ask the department to give clarity on that, the Constitution 139 only makes provision for the appointment of an administrator in the case of 139C when a municipality is dissolved. Now, what is happening is, and that also was absolutely demonstrated by the case study of SALGA, that administrators are being appointed, and without terms of reference, without any reference on what is the things that they need to do, what is the task and the functions, what is the clear sort of a plan and the way forward, and how communication and the cooperation between the existing staff in that municipality and that so-called administrator have to be. Then on the monitoring, on the embassy bill, I totally agree about the early warning systems. I have a big concern, Chair, about that the municipalities have to have create for themselves early warning systems, which I agree it should be, but we have tales of two worlds in this at the moment. Municipalities who are functioning well and those who are not functioning well, and we have to make sure that if a municipality would have the ability to have an early warning system and react on it, they should not land up with an intervention. And how are we going to address that kind of oversight in the embassy bill? And I think the reference to the Public Administration Management Act that already makes provision for early warning systems, I think we we need to look at that. And is there a list of these things that municipalities and or provincial departments should use to say this is what we need to monitor to make sure that we pick up on the early warning systems if they don't pick up on that themselves. And then I have a big issue and a big concern about the cooperation in the IMSI bill, chapter 4, 5, and 6. And if we go later on the other instruments of support, as been clearly indicated by the department, there's a lot of grants, there's a lot of those things. The cooperation between the various departments of provincial COCTA as well as national COCTA, in terms of the understanding and the implementation of these various criteria and terms, and then the reports that has to go, because one of the things that's mentioned, for instance, is that Treasury, if there's a financial recovery plan, Treasury wants certain reports. If it's on service delivery, COCTA wants certain reports, and that feedback should go back to Treasury. We should look at IMSI that the same report, that the same report. Sorry, sir, there's a lot. That the same report that is going to Treasury should go to the select committee in the NCOP who determines whether intervention should stop or go on. We can't use two different systems. And that same report that's going to Treasury should go to provincial COCTA. We should use the same standardized kind of report for decision making, so that we can't. That will also cut out the political decision making on interventions. Then, Chair, I just want to ask on the municipality support infrastructure, that slide where they gave us the most vulnerable or the distressed municipalities, and that support system. The MISIPs also use the pillars, and that local economic development. I have a big concern about the interpretation and the priorities in these municipalities. I know it's one of the 6 pillars as in the Constitution, but if a municipality interprets that, for instance, local economic development is a bigger priority than basic services, and then, for instance, go and sponsor a soccer team for 27 million, as we've got in one of our oversights, while people don't have water and electricity, then I have a big problem. So I think we should unpack that in the white paper as well. And then the Presidential Working Group Chair, I think it's, I do understand it now, and I think it's a good idea. I would like us to in the white paper and or in the IMSI bill, make sure that there's a transversal way of working in provinces in these various departments, because that presidential working group is now at the moment focused on metros, but we have a big problem on the level of other provincial of other municipalities. Last one, Chair.
Let's round up.
The other instruments that support municipalities, that's the reports 71, 76, all these things, the blue drop system, the effectiveness of the various grants, as they said, the MIC and the WSIG and the USDG, some of Department of Water and Sanitation, some of Human Settlements, and all these things. Is there? I would suggest that we focus on the fact that these things are there. How are they? Is there a single system and sort of? How are that being monitored? Because if we say we have a municipality and they have to to give reports in all various directions and all these things, I can just imagine that it's very difficult then to pick up on your own early warning systems. So they are very regulated. But I would, from our side, in our oversight capacity, think either in all the IMSI bill or in the white paper, make sure that if we can simplify and find a framework that of a transversal system where all the various types of municipalities and have to determine this is the type of feedback that needs to come from this type of municipality, and that is the type of feedback that is indicative, and that will form our early warning system, make use of the same kind of data sets and IT. I think that will bring us a long way. But at the moment, as fragmentized as it is, I have a big concern about that. Thank you very much, Chair.
Thank you, Honorable Taiposh.
Thank you, Chair. Greetings, Chair, honorable members, the DDG, all the senior COCTA staff. Chair, I have a problem with the nature of the Section 154 support. You know, in the back of my mind, it's like we're cushioning what should happen in real life. We are forming like almost a soft pillow to say, you know, we cannot come down too hard on these people. Personally, the IMSI bill, in my mind, sorry to say it, is another piece of legislation which I believe if people do their work, and if people that don't do their work, all right, if consequence management is applied in every instance like it should be, then there's no need for an IMSI bill. I believe that there were administrations before this administration. There were many before, and people did wonderfully well with those administrations. Yeah, we are jumping through hoops and going over barriers and going over mountains to try and ensure that municipalities perform. Why? I wrote to the Minister of COCTA on numerous occasions and asked, why are we doing this thing of unfunded budgets? People are being allowed to not submit their annual financials year after year, after 10 years, and nothing happens. Only now something happens. But there where somebody, there's a special intervention going on at Maluti Apofung. Last week, I've got a whistleblower there. Just last week, I got a long email of all the shenanigans that's still going on. Yet, since last year, October, there's been a special intervention going on there. But on the ground, people are still looting. Anyway, there's no other word for it. I cannot say corrupt or fraud. It's looting at the rate that it's going. Chair, there are some, you know, the support interventions that SALGA is mentioning. All right, the reports, the 71 and the MFMA section 71 and 72, and there's MSA section 46 reports. If those reports are being used properly, these things, these are early warning systems. Okay, but the problem here is, and I could sense, and I don't want to put our friend Lance Joel on the spot, but I could sense that they're not happy because they are being blocked by municipalities. They're not being consulted to come and help because municipalities and municipal managers and officials do not want SALGA to see what is happening. They are blocking them basically, so they are not involved in them when they have problems. And that's why they get away with what they get away with, and really nothing, you know, nothing really happens in terms of that, because as we all know, consequence management is a very fancy word. Very, very fancy word. If I look at a municipality like Empuleni, Mangaung, Ditsobotla, I put Maluti Opofung and what, it's been years. It's been years that we've been complaining about what is going on. You know, you've brought in Empuleni, I think they had probably about 8 or 9 administrators already. Something is not right. Why is it that we are taking so long to take proper action? Hold people accountable for the things that they are doing. Don't deploy them elsewhere and promote them. Hold them accountable. That's what we should do. We shouldn't be, what you call it, we shouldn't be doing, they're asking, and I mean, there's this Lance question himself whether, these special support interventions, are they working? Are they appropriately packaged? There's nothing wrong with them. They are good. They are very well packaged. The problem is where there is no will, all right? You can package it any way you want it. You can make magic. It will not make a difference. It will not make a difference because there is no political will and people get away with murder and they're allowed to do what they want to do. And unfortunately, there's no consequence management. And now we're introducing another bill here to make it, just to say, we're going to wrap you over the knuckles, but you must stop it now, you naughty child, and then we move on. No, it's never going to change unless we tighten the screws and we become serious with consequence management. And municipal managers must sign agreements that, if they mess up, they will, first of all, they will face the law and they will be gone. There's no second chances. You can't have second chances with people running municipalities that are getting over 500 million rand. Wrong. You cannot do that. It's like throwing money into a big black hole year after year after year. So, Chair, my what you call it is SALGA should be taken more serious, and there should be that should be made official almost, because SALGA is doing a lot of good work all these years and a lot of times, and they know what they're doing, but they've been kept out there. They've been kept outside so that they cannot see what's going on, and they cannot so that their hands don't get dirty too. But that's good for them because they're doing a good job. They should continue to do that. And but the problem why they're not being involved is because the people on the inside does not want them to see what's going on. Thank you, Chair. I rest my case.
Thank you, Honorable Taiposh. Honorable Sompa Masivo.
Thanks, Chair. Me, I'm just having 2 questions that I will need clarity on. One will be, let me greet first, sorry, Chair, to greet you, Chair, and the members of COCTA, Department of COCTA and SALGA. My question will be on the first presentation, where I just wanted clarity of what is the yardstick that the MEC is using to assess municipalities that are not doing well. For example, in Northwest, the majority of municipalities have collapsed. In Matlosana, every day there is the issue of the CO, the issue of the MM. Now, recently is the issue of the mayor, who there are issues, lot of issues. They bought a table of 284,000. That is worth 15,000. Now, I just want to check with the department the accountability of MECs to the office of the minister in terms of saying that the report must come, or the assessments report must come from the municipalities, because as we are standing, like Honorable Kalipi have said, we want to know the tools that they are using to make sure that this municipality is collapsing. While it's still it's in the end of collapsing, then they will be able to say there is a danger in that municipality. How best can we be able to stop it? Because now they are becoming at the fourth and a half. almost 4 years full on their office term, but the majority of them, beside Northwest, the entire country, there is a crisis of municipalities that are collapsing for the issues of corruptions, maladministration, and all those things. And then the other issue that I want to ask is the issue of does the department have a report in terms of where all there were administrators that were appointed to municipalities? Does they have a report or there was administrator in this municipality of Mamusa, for example, and then this was the outcome, the intervention that we have done. Was it good? Did it work for the municipality? Because I can tell you, as I speak now, a lot of administrators that are sent by the MECs to municipalities, they are making things worse. They end up being the one who have put their hands on the cookie jar. Now, I just want to check with them that do they have those reports? If they haven't, maybe they will send us those reports, consolidated reports, that we can table to say, guys, these things the tools that you are using, it's not working. Really, it's not working. What can we do to make sure that we assist municipalities, or we clean out this method that you are using? This is another tool that we can use to make sure that the next coming administration, they don't do the same mistakes, because they've been doing them for the past 30 years. So that is why municipalities are on their knees. Others are just in a brink of just being buried. The following day, when people go to the municipality, they see that there is no municipality anymore. So that's what I just wanted to check. Do they have that report that say, out of 270 200 and something municipalities that we have in South Africa, this is the number of the municipalities that were given administrators. This is the outcome, positive outcome that came from that intervention that we have done, because it's not working at all. Thank you, Chair.
Thank you very much. Let's have Honorable Direko.
Thank you, Chair. Greetings, Chair. Greetings to colleagues and all the stakeholders who are part of our meeting. Chair, most of the questions that I have been covered by my colleagues. However, Chair, I also want to emphasize on what Honorable Mukhalipi have just raised on the provincial and national government being able to identify possible preventive measures on municipalities with challenges that can lead or may lead to municipality being put under any form of intervention. Therefore, Chair, I would like to check with the department, how does the IMSI bill address the root cause of municipalities and provincial failures to prevent the need for intervention on our municipalities? Secondly, Chair, can we also get a clarity on the working relationship between the national government, provincial government, and SALGA when it comes to putting municipality under the administration? The reason why I'm asking this is informed by the statement that was made by Mr. Lance on the issue of Tshwane intervention, whereby the SALGA was not also taken along on that particular matter. And thirdly, Chair, is on the intervention. I don't know if we can confidently say the intervention is working. The reason why I'm saying that is that in the province where I come from, most of municipalities which were put under administration, instead of improving, they become worse when the administrator comes there. And I also want to check if is there any a time frame for intervention in our municipalities, because in some municipalities, these ones who are distressed, these ones who are consecutive offenders in terms of the disclaimer outcomes, have been put on intervention. We have municipalities in Free State who have been on intervention for more than 10 years, but the situation is not improving. Instead, it becomes worse each and every day. And then, Chair, the other one, the last one is, I also want to get the view of SALGA on this one. There are municipalities where you send the administrator in that particular municipality. 4 months, 5 months down the line, that particular administrator then
becomes appointed as the accounting officer of that particular municipality. So in terms of SALGA, is there any form of a way where we can regulate this particular thing? Because in those municipalities, like for instance, we talk about Mafube now, the administrator that was sent into Mafube was then appointed as the MM of that particular municipality. And along the line, it was then realized that the appointment was not lawful. Then it then posed the question as to, you send this particular person who's supposed to be expert on the local government, but then when he arrives in that particular municipality, he's the one who, with the municipality, who are committing this unlawful, unnecessary mistakes in that particular municipality. Thank you, Chair. That's all.
Thank you, Nkosip.
Good morning, and thank you very much, Chair Toabe. I would like to greet our visitors who have presented this morning, and thank you for the presentations. And also I greet my colleagues in the committee. Chair, you know, yesterday there was a slide that was put up at this white paper launch, which was, full of all forms of legislation that have been tried over time. And really, it left a cold feeling in the stomach, because, you know, you get the feeling that I ask myself a question: are we maybe not legislation fatigued, but at the same time with nothing to show? So really, that's really my opening bit on this MC bill, that there is so much legislation. I don't know whether we pause at some stage to look at, to weigh legislation against the results that we achieve. I just think then, moving on, Chair, because a lot of what I wanted to say also has been covered, and I won't repeat, but emphasize certain things from my perspective. I think there should be a balance between the carrot and the stick in terms of this intervention, because I think the emphasis should be on capacitating the municipalities rather than emphasizing VRV beating them up. I think that really should be looked at very, very closely. I don't have much to say on the early warning system. I'm also just reiterating what my colleagues have said, that there's no point having an early warning system which does not actually warn you early. So really, that's enough said on that one. The question that I feel quite strongly about as well is the one of administrators, Chair. I mean, there's no rule book, or there isn't any that I'm aware of. It's just too open-ended. Some of these guys have been in place for years and years with no indication of any roadmap and the difference that they've made. And I think there's no situation which is worse than people who have come to intervene then end up exacerbating the situation. Actually, I've never heard, Chair, once that an administrator has been moved because he wasn't delivering. Maybe some of you have heard that. And there is no way that just like in any situation, that all these guys are perfect. I've never heard that, one has been moved because they were. So is there also consequence management on these administrators? The other thing which I've always felt strongly about, Chair, is that, are we ever going to get to the point that there's accountability for the council, the people who sit in the council? Because, you know, I really think this must be seriously revisited or be looked into, because emphasis is on the mayor and the MM and whatever. But there is a team there of people, the councillors, and I've never heard that there's anything that is directed at them in terms of failure to deliver. Just like in companies, it should act like, really, to me, it should be like that they are jointly and severally responsible, because there are so many of them there who are just oxygen thieves. So I think that is something I've always felt strongly about. And then also in terms of intervention, Chair, my question would be, this intervention, who polices the policeman? Because this intervention, at times, it must also be measured. It can't just bamble along. And then, because I really wanted to save time, I just thought I'll raise those points. And then also the point of this depoliticizing, which came up yesterday. I know that we are looking forward, but I think it's very important that focus must be on it, because these municipalities actually are riddled with political, interference. And I think that it's a very big aspect of it. And also you find this situation where these days now with coalitions, people I mean, they are using their votes as bargaining chips in terms of some issues there. And then lastly, maybe for me, Chair, of these 40 municipalities which are in trouble, I don't know, from my side, I never have heard of a time horizon or a time frame in terms of that you can monitor once there's a time frame that you are looking against, that when are we the trajectory going downwards? What time frames are you looking at by when? I thought from my perspective, Chair, those really are the things that I felt, besides then the ones that a lot of them that my colleagues had already raised. I thank you, Chair.
Thank you very much, Honorable Buthelezi. May we then ask the team to respond, but just to make a point here that there's an issue that is intangible, but which is important, and that is the issue of the will to get things to be done properly. I think that's one of the issues that are very difficult to deal with, but part of what we're trying to make the laws to correct is something that can be corrected if people have got a will to cooperate. The issue of cooperation, cooperative governance, is also very elusive in terms of how you can force people to cooperate. You know, part of the issues raised by the Honorable Tetwa about the structure of government comes from the nature of the government we have. We're not having a unitary government, but we've got a government with lots of federal features. Therefore, each one of these spheres has got their own powers that cannot be stopped by another sphere. And at this point, it becomes then important for each one to be prepared to cooperate. So the issues of consequence management, holding people to account, become very important here, because there's always going to be a gap where one person will want to interpret the same law that has clarified everything with many many ways. So these are the issues. And I'm not sure what SALGA's role is in dealing with the issue of encouraging the cooperation of its own members with the legislation, more than only looking at whether the higher sphere has acted. I think it's correct to look at whether they've transgressed their authority and whether, in fact, they've taken into account all the concerns, the early warning signs and everything. But I think we need to have a role on both sides to encourage the cooperation, because it's really where the issue is stuck. But anyway, the members have raised all these concerns. Can we get back to response? May I get Mr. Lance Joel first to respond, because he's got a flight to catch, and then we'll open up after that for the remainder of the teams to take us through their responses. Lance Joel.
Thank you very much, Chairperson, and thanks for accommodating me in responding first. We really appreciate the comments and the questions that are coming from members of the portfolio committee. Some of the direct responses. Firstly, Chair, I think we agree with the Honorable Kalipi that the IMSI bill, it is not the solution to all of the ills that finds expression in the local government space and how support is directed. That we absolutely agree with. But what it does, which we must give it credit for, Chairperson, is that it is starting to create uniformity, standardization, and through a framework that would then be forced upon those that are obligated by the Constitution to direct support to local government, but also where they do ultimately take a decision to intervene, that there is proper guidance given to them in doing so, and that is a real benefit that comes from the bill itself. The second issue, the question asked by Honorable Kalipi I think it's a direct question to both COCTA and ourselves, whether we have the capacity for early warning systems. Well, as a starting point, Chairperson, we are Section 71, Section 72, the MSA Section 46 reports are reports that we don't have access to as SALGA. We are not in the loop when municipalities are reporting on their financial statements, on the execution of the IDPs and the related plans. Those go to national and provincial government. So firstly, we are not in the loop. We don't get those reports. We don't get first-hand view of what is being reported by municipalities. But certainly, I do believe, working with COCTA, I do believe we have the same intent, we have the same desire that we could develop the capacity in a very short space of time, develop the capacity based on work that has already started on the side of COCTA, but also work that we have started as SALGA and build that capacity, because the reality is that the value attached to early warning systems and making them effective is really going to turn the tide for local government, more so in that we would be having the benefit of a picture that is more real and live on what is happening within municipalities, and being able to project potential challenges that may emerge in the future, and already proactively identify, firstly, what an appropriate response would be, but secondly, who is best geared to direct that support to municipalities. So you will also have a more coordinated and facilitated plan of support to municipalities. An issue raised by Honorable Laviskafni, the question is a direct question. What are the consequences if an early warning system is, well, if early warning systems are ignored? I think when we look at the state of local government now, that's the consequence of early warning systems being ignored, simply based on the point that I've made earlier in the presentation, that as SALGA, we do think that currently, outside of the IMSI bill, those Section 171, 72, and Section 46 reports provide a solid basis of an early warning system. And they are literally being ignored or not sufficiently used to respond to issues within local government. So that's the consequence of an early warning system being ignored, as it does paint pictures of difficulties that may be experienced by municipalities. The Honorable Director has asked a question about the working relations between SALGA, national and provincial government when it comes to interventions themselves. Our response is that when you look at interventions, there's a pre-intervention phase, there is a direct intervention phase, then there's a post-intervention phase. We believe as SALGA that we can contribute at all three levels: pre an intervention, during an intervention, post an intervention. And we have raised our hand on several opportunities given to us to be part of the process, because we do believe we can provide assistance. And we continue to extend our hand of saying we want to be part of the solution, pre, during, or post an intervention, and we would want to collaborate with any role player in the space for the betterment of municipalities. I thought the point made by Honorable Director on yes, we also acknowledge, I think it's something we have also picked up, that administrators that come to a municipality through an intervention are later appointed substantively into that position as municipal manager and that be regulated. I am not sure whether it is an issue of regulation itself or whether we should have trust in the process of recruitment, because one would assume that when a position is vacant of municipal manager, that anyone that is interested in that position would have to go through that recruitment process. So we can't short circuit that process, go through that recruitment process, meet the requirements, and fulfill all of those requirements during the process. Ultimately, if they are then selected for appointment. The only way to regulate that is to regulate the recruitment process. I don't think there's any other way that we would want to regulate those appointments other than dealing with the recruitment process itself. Honorable Buthelezi, we are absolutely in agreement with you. You are raising some points that you may have heard SALGA raising before. The first one of those is what you call legislation fatigue. We call it the strangulation of local government. Local government, it was raised yesterday during the white paper review launch process that local government is overregulated. And there's perhaps a reason why local government is overregulated. And when you look closely at it, firstly, is that there's a trust deficit. Every time something goes wrong in one municipality, we will develop a regulation or a law that will apply to all municipalities. So there's a lot of trust deficit that finds expression in our space. There is the removal of discretion, because we believe that when you allow discretion, it will be wrongly applied and it will not be in the best interest. And it is really created a difficulty in the local government space that there's very little room for discretion. Everything is to the T regulated. That does concern us. But to take it further, a point that was made earlier about the number of reporting requirements. In the local government space, there are 75 legislative reporting requirements. So the administration within our municipalities are constantly busy with reports. It's not necessarily reports that are developed for own benefit and use. It is for the benefit of the reporting requirements to one or the other department, national government, provincial government. And that does impact on the ability to be responsive, because a lot of time is spent on reporting itself. And then we see that those reports are not effectively used as tools to direct support to municipalities when necessary, intervene in those municipalities. We also agree with you, Honorable Buthelezi, that there is, in terms of the current white paper, there's an obligation of both national and provincial government to develop the capacity of local government. And we want to continue to campaign for that continuous capacitation of municipalities, rather, as you have put it, the destroying of our municipalities. So, Chair, those are the issues that have been raised by the members that as SALGA we would want to respond to, but we also want to make a commitment, Chairperson, and I think it's been said by the President of SALGA and many members of the SALGA leadership, that as SALGA we do have a role to play in ensuring that not only are we the voice of local government, but we also have to be the voice of reason with local government, with our municipalities, including raising our concerns about developments within the local government space, including where there is a sense that local authorities themselves are not collaborating with provincial and national government. And we remain committed to ensure that our role is not only to be the voice of local government, but also the voice of reason to our members within the local government space, including where there are weaknesses, where there are shortcomings, and how we should be advising them in taking perhaps a different or an alternative approach to be part of the solution. Those are the responses, Chairperson. Thank you very much.
Okay. Let's allow the rest of the team to respond. Dr. Naidu. Am I having a problem?
Yeah. Thank you very much, Honorable Chair. I am going to request my colleague, DDG Duma, to respond to the municipal specific questions that were raised, including Matlosana, the practical experience of Section 154, the matters relating to municipal specific intervention plans, support plans, whether interventions do work in instances where it has been applied. Mr. Kasi, who's been the key driver, the anchor of the IMSI bill chair, I'm going to ask to deal with matters relating to the empirical evidence that has been cited, the matters relating to the terms of reference for the administrator. He can also deal with the early warning systems, and then I will come in and also provide my views on certain of the matters. With that, Mr. Duma.
Thank you, Dr. Naidu, Chairperson, members. I'm going to try and respond to a few questions as indicated by Dr. Naidu, but let me start with the early warning system that has been spoken about in this meeting on a number of occasions, and perhaps deposit my views on that to say, Chairperson, across government there are systems, there are early warning systems, whether they are enough and whether they are effective. Perhaps that's a few. Municipalities are required to produce what we call Section 71 reports, which are monthly reports, and Section 54 reports, which are quarterly reports. They also produce in-year reports, which are Section 72 reports. There's also M-Score, which is being implemented by Treasury, which collects information on a monthly basis from municipalities. They also prepare annual financial statements, annual reports. So there's a whole range of reports that municipalities produce, which can be classified or which can be used to detect anomalies in each of these municipalities. Chair, on the question of Machabeng, I will not get into the issues raised about the speaker, but just to indicate that indeed in Machabeng, the court directed that, or issued an order directing the province to intervene in terms of Section 139.5 late last year, but that was appealed by the municipality. And we know now that as the court dismissed that appeal last week, and the province has indicated that they are proceeding with that intervention in terms of Section 139.5 of the Constitution. In the case of Likwa, having remained under intervention post the 2021 local government election, They are not the only ones, Chair. There are quite a few other municipalities. I can mention Umzinyati, Mbofana, and a few others where the intervention started in the previous term and they are persisting even now. Maybe it's a matter that the courts may need to clarify at some point whether the intervention falls off when there is a new council. But just to indicate that the legislation across the law, the reference is made to the intervention in the municipality. And the municipality is more than just the municipal council. I'll leave it at that. Colleagues will add if there's a need to add. There was a question of whether the government, national government and provincial government who prescribe the laws, whether they are the right authority to crack the whip on municipalities that are not complying, and I would say yes. The fact that these two spheres are providing support to municipalities doesn't take away from the fact that they have a responsibility to ensure that municipalities do what they are expected to do at the end of the day. And again, that is be clarified by the laws, by the courts. On the question from Member Lapaskafni on whether there is a standing operating procedure on how we support municipalities, and I think to a large extent, and colleagues will add, the IMSI bill is attempting to put that procedure in place so that there is uniformity across all the provinces. And at this point, Chairperson, let me add that members will be aware that the application of Section 139 in particular is hierarchical, in the sense that provinces are the first port of call if there is a problem in the municipality and there's a need to intervene in terms of Section 139. Both Section 139 or Section 139.1 and Section 139.4, Section 139.5 have to be first applied by the provinces. It is only when the provinces fail or omit to intervene in terms of Section 139.4 and 5 that national government can intervene. So in that sense, the provinces perhaps could be engaged by the committee at some point to delve into some of these matters that are being raised here today. On the question of whether administrators are appointed only when there is a dissolution, and I think that I would want to refer members to Section 35 of the Structures Act, which allows MECs to appoint administrators not only when a municipal council is dissolved, but also when a municipal council does not have enough members to form a quorum. So, and there is enough case law, Chairperson, around the appointment of administrators in municipalities, and the courts have accepted that it's not only when there is a dissolution. And perhaps the terminology there could be used differently so that there is a differentiation between a dissolved municipality and a municipality that is under intervention in terms of the other instruments. So on the question of whether on the effectiveness of conditional grants, on whether there is a single system or transversal system to coordinate the support that get given to municipalities. National Treasury has been working on a system whereby there is consolidation of these grants and that is work in progress, and perhaps they would be best placed to talk to that. But it was an attempt to ensure that there is that coordination. But further than that, Chairperson, the requires all the spheres of government to ensure that there is that coordination in the application of all these instruments that we use to support municipalities, including conditional grants. Chairperson, I think I will stop there, and perhaps then the colleagues will touch on the other questions that have been raised by the members. Thank you, Chair.
Much, DDG Naidu.
Are you connected?
It will be.
Yes, Dr. Naidu.
Apologies, we were muted. Thank you very much to Chair, Honorable MPs, all protocol. Honorable Chair, I would touch on one or two things or responses. Just to indicate that we would like to indicate that we do not consider the IMSI bill to be a panacea of all challenges that will be encountered by the municipalities or even the provinces, Chair. The bill basically is not an armchair developed bill, and it has taken a lot from the empirical experiences, the evolution and practices on invocation of this intervention. To input on the issue of the limitation to failures to fulfill an executive obligation, led to difficulties in interpreting when an intervention is permitted and what steps are permitted. Chair, I must say this is also similar to the notion that the provinces interpret interventions separately from each other. The bill basically is attempting to bring uniformity, as it was said earlier on by DCoG Duma, to all. Basically, empirical experience and the evolution of the application of intervention in terms of Section 139 of the Constitution have assisted us in crafting, the provisions of the bill. Now, the bill as it stands, firstly, to get into the matter, it now defines what an executive obligation is, and this was taken from the Tshwane dissolution of the municipal council, a case that was alluded to by SALGA earlier on, and we have extrapolated the definition of the executive obligation from that jurisprudence, and we are hoping that this matter will be led to rest in terms of, how everyone is interpreting what an executive obligation is. Secondly, as I'm trying to be brief, Chair, is the issue of that was asked whether are we sending the right, skills as administrators are being sent to municipalities to undertake the work that they are supposed to be taking. I must say, Chair, the issues around administrators came through very strongly from the honorable members, members of Parliament, and we indeed are saying that the bill now definitely is dealing with issues such as qualifications and issuing out of terms of reference, issues around the remuneration and all those, so that we apply uniformity to regulatory matters that get towards, regulating the administrators. Chair, there was an issue around removal of administrators, and I thought DDG Duma would talk to it as someone who's coming from KZN. There were a lot of administrators that were removed before because of one reason or the other, including capacity issues. Indeed, around the issue of accountability of councillors outside of MM and Speaker, yes, it's simplistic for us to say we've got a code of conduct for the councillors, but I must say, and this maybe will be resolved as we are presenting the bill before this portfolio committee, to circumvent the issue of councillors having been dissolved. More often than not, there would be candidates in the by-election and come back as those councillors. So there are clauses that we are wanting to put. You see, the bill has been developed within the confines of the constitutional prescripts. Now, the Constitution speaks of if there is a vacancy in a councillor, then there has to be a by-election in 30 days. So every bill has to follow that, or law. Now, to circumvent this challenge is that we are having a clause around regulation on 2-year cooling period for councillors who have been found to have caused the intervention to be invoked. Lastly, towards the end, Chair, around the issue of timeframes as to when the intervention starts, and like the name is saying of the MC bill, it's intergovernmental monitoring. The bill first instigate for monitoring of the municipalities. Out of the monitoring, we'll get a diagnosis of the challenges that the municipalities are facing. And out of that diagnosis, then support will be provided to mirror the challenges that the municipalities are facing. Failing, then it will go to variety of intervention as a last resort in terms of Section 139 of the Constitution. That is to say, MC bill, it's intergovernmental, monitoring first, and then providing support, and then intervening as a last step. Chair, I think DDG Duma has also touched on issues around the self-monitoring and all. With that, Chair, I think the other issue, crucial one that has been raised, was around the reports of the administrators. We have to indicate that in the bill, indeed, submission of the administrator's report is compulsory from the province, and the province will be taking that from the administrators. But indeed, we have been some assessment reports on how intervention were undertaken. Yes, the minister has been getting such, though in some instances, the minister didn't get any. With that, thank you very much, Dr. Naidu.
Thank you. Dr. Naidu, you want to proceed from there?
Thank you very much, Mr. Kasi and DDG Duma. Chair, I'd like to make 3 points. The first, dealing with the early warning system, and I think much has been said by various colleagues, members on the platform. Now, to say whether Section 71, 72, and Section 46 reports are early warning systems is debatable, because much of it is post facto. And I think the early warning system that is envisaged in the legislation would be a system that would give one red flags much sooner than the reports that have been cited here. If you look at the Section 46 report, for example, the Section 46 report comes or is finalized by the Auditor General in November, so 5 months after the end of the financial year, which then still needs to serve before Council and only gets finalized by the end of March after the financial year has ended of a municipality. Of course, we then look at that being processed by provinces, highlighting the need or trying to identify those areas that would need to be attended to, etc. And only then does it become available through the Provincial Gazette, which is then looked at by national government, the national minister, which requires a Section 48 report to be developed. And that would be after a full year of the municipal financial year of municipalities. So a stark difference from what is happening presently in terms of what one may consider an early warning system, and that which is envisaged in the IMSI bill, and that which is envisaged in terms of the Public Administration Management Act. There's the office as is required in terms of the Palmer Act. That office, as far as I know, has not been established. And when it has been, we would need to see how we influence and inform the uniformity and the early warning that would be developed in terms of that section, in terms of that early warning system. Secondly, the issue around the white paper and the launch and the process that has been currently underway. I think a lot has been said by Honorable Mtetwa, for example, various issues raised. And I think, as part of dealing or processing those submissions, not just from Honorable Buthelezi, Chair, but also from other members, I think let's try and co-create, co-shape the future for local government, and let's make those submissions to inform how we want to see the future landscape of local government. So we encourage those submissions to inform that process. Thirdly, and I think also there's a lot of excitement around the IMSI bill, something that has been on the agenda for quite some time. Many of the members have spoken about the provisions therein. Honorable Buthelezi raised the issue of legislation fatigue, something that SALGA calls strangulation. But I think the point made by the Honorable Chairperson, which is willing to cooperate, underpins the need or no need for regulation, be it in the form of regulations, primary legislation, etc. Now, we're still far from the finish line in terms of the IMSI bill becoming law. The form and shape of it presently, Chair, could change drastically after the consultation processes that must be undertaken. I think in the last engagement that we had, we touched on how that public consultation could be undertaken. Of course, it is the call of the committee. It would be the call of the select committee. It would be the call of the provincial legislatures in terms of how consultation would be undertaken in respect of the bill. But in those consultations, the issues that have been raised in the committee now could be a drop in the ocean compared to what would happen in the consultation process. And I think through those various engagements, Honorable Chair, it could shape what eventually becomes the bill that we would want to place before the President for consideration. So I thought I'd make those comments, those inputs in relation to the matters generally, Chair, and with that, hand over to yourself. Thank you very much.
Thank you very much, Councillor De Vos. Are you still around?
Yes.
Okay. Okay. Yes, you have an opportunity. We only allowed Joel to comment and leave because he asked to leave, but you are free to comment. Members will come back with the concluding comments, and then we'll take it from there. But if you want to come in now, okay, you can come later. Councillor De Vos. That's fine. We can hold it for now. Honorable members, those are the responses. Do you wish to make any follow-ups? Any aspect you feel needs to be further clarified? Anything that was not very clear? Can you have this opportunity? Honorable
Thank you very much.
Labuskaghni.
Thank you very much, Chair. I just want to ask one question, if I may. Thank you very much for the feedback to the department and to SALGA. I just want to ask on I do understand and I totally agree with the fact that you said that Section 71 and 72 and Section 46 reports is all reports that the action that we are launching or the department is launching is recreative. You know, it's not proactive. It's afterwards, and that you then refer to in the IMSI bill will be built upon the norms and standards, and most probably thresholds should be created that trigger intervention or support by the Public Administration Management Act. And then I've missed it, that what in connection with the Public Administration Management Act is not in place yet. And do you, I know it's an unfair question, but just to know, do you perhaps have an idea of the time frame that would take? Because before that is in place, because if the IMSI bill, say for instance, takes another year or 1.5 years, as we know, as you've already alluded to, that might take some time before it becomes a legislation. The same thing might happen to the Public Administration Management Act. And if we can have a time frame and maybe chairperson, that's something that from our side we should maybe sort of flag for a little bit of a cooperation and sort of making it a priority that should follow the same timeline if possible. Thank you, sir.
Honorable members, any other? Are you comfortable that all your questions have been properly addressed? Wish to make any other comment? If not, we'll proceed. Okay, Dr. Nai, do you want to pick on that one?
Yes, thank you very much, Honorable Chair and Honorable Labuschagne, for the unfair question. Honorable Chair, I wouldn't want to volunteer a response on behalf of the Department of Public Service and Administration. Safe to say that we have had an initial engagement with them to impress upon them the urgency or the need for the system to be in place and to be available at the same time that the IMSI bill becomes law. With that, thank you very much, Honorable Chair.
Well, thank you very much. I think this has been very, very important discussion. And so thanks to the department's presentation, and thanks to SALGA for the comments. I was commenting earlier about this issue of cooperative governance, because actually it's a concept that is very new in the vocabulary of South African governance. And it was really occasioned by the fact that the formation of the new government, the post-apartheid government, was no longer a single unitary government, but it was now a government that took a lot of federal features from various countries, and mainly from Germany, the German Federal Republic, and with the different powers of the different spheres. Then what was never brought to us was the issue that relates to what is called in Germany is the responsibility to cooperate. And they have a term they call the Bundestruhe, which basically has the courts frowning upon any sphere of government that brings a matter of intergovernmental relations and poor cooperations and overlapping powers to court. They are actually obliged to sit down, negotiate, focus on what their primary responsibilities are, and out of that decide on how to manage concurrency of powers where there's an overlapping mandate. So this is really the crux of this issue. You can make many laws around it, but there has to be this an overriding spirit with the desire to cooperate and the will to work together, because then it will then reduce the need for each one to run to courts, as it were. Now, in some of the instances here, people run to court when there's an intervention based on their poor performance or lack of performance. And of course, it's important to make sure that the one sphere does not bully the other. But it's also important to know that there's a responsibility for intervention where service delivery is affected. And I think that that's the part we need to try and infuse in the white paper, in the legislation, that at the end there will have to be some intervention and there has to be an agreement that let's focus on the real issue that is about service delivery, lapses that have to be corrected. And so the issues raised by members here relate really to the question of, at a certain point, we shouldn't really be quibbling about interpretation of the legislation. We should be focusing on the objective. We are supposed to ensure that there's good service delivery, and that's it. And we're supposed to make sure that people are accountable. We're supposed to make sure that, excuse me, we're supposed to make sure that there's consequence management, and we're supposed to make sure that each one of us continues to participate and do what their powers and responsibilities are about. And so I'm hoping that as we move on in this whole discussion, there will then be that clarity. I think one thing that has always been important to clarify for the committee is the presidential working groups in terms of how that is classified. It's very, very important because we shouldn't be having any contradiction in the way we are approaching the matters. And the question of what the role of the early warning systems is going to be, again, I think we need to just refine our views so that at the end, there should not be a question of whether this provision of the MFMA does help us as an early warning system or not. We need to have a consensus on that, because one day the municipality will be going to court on the basis of which warning system was used to actually take a decision to intervene and whether it's appropriate or not. And we want to really get out of the kind of quibbling with the semantics, but to focus on the real objective of service delivery. So that for us, I think, was why this discussion was very, very important. And so thanks very much for all those comments and those responses. Honorable Mtetwa, I see you've got your hands up again.
Thank you, Chair. Thank you, Chair. I just wanted to make exactly the point you were making, that this bill we are talking about here, it's like it can only work in a unitary state, or where there's either one party state or two party state, not in a multi-party state and in a power sharing environment, because it exposes the differences of different persuasion of different racial groups and political groups, especially now if you are lumped together. When you are in government, you are pulling and pushing for your ends individually, yet in a unitary government system, and you are not able to pass a law, a policy at national, and make sure that it is seamlessly implemented down to local government. So that is exposing us, but we are yet to find unity at political level first, so that we all agree on a same national agenda, same national vision. And once that is achieved, when we get to government, we don't differ on our persuasion and appearance externally or as different groupings. Thank you.
Thank you very much. Actually, we need to find a way of crafting the legislation such that it must survive party political differences, but focus on the unifying objective of how we can improve governance, how we can facilitate and improve service delivery, and how we can improve the lives of our people, irrespective of the political persuasion or ideological differences amongst the members of one or several parties, and whether, in fact, the legislation should survive the dynamics of coalition governments, which means at the end, there must be the impact on the system of governance more than a legislation that will depend on individual power dynamics of political parties in relation to what the citizens' expectations are of what service delivery, satisfactory service delivery should be about. Honorable Telezi.
Thank you, Chair. Thanks for the opportunity. Just a very, very small point. I think if I heard correctly on my point about councillors being held responsible, I think I heard the response was to the effect that sometimes a councillor will leave and then the party reappoints. I think that maybe what will be helpful there is that you are regulating the space of the municipality. You are not getting involved who's being sent there. All that you are saying is that it's just like someone when he has been struck off the roll as a lawyer or whatever. I think that's the best example I can think of, that in this space here, you were removed for this reason. So there's no way, but it touches on what you've just said, Chair, that really there must be a Chinese wall between regulating the municipality, how it works, and the political parties. Because if they return someone who's already tainted and who was removed, then the regulation must be there. There must be a clause that say you cannot unless then they decide you will be rehabilitated over whatever period, if that's a decision. So I just thought on that point, that to be one of the most important installments in making sure that you don't find a tainted person making it can't be a revolving door, because that's what's happening now. It's a revolving door of all sorts of people, corrupt people and politicians. I just thought I'll make that point if I heard properly, Chair. Then thanks to Abe.
Thank you very much, Shenge. Yes, I think we will all be concerned about the integrity and stability of the administrative system, irrespective of the dynamics of individuals that come in and out, especially of the political segment of the municipality. That's why I think the question of dissolving a municipality, or sort of intervention in a municipality, appointing an administrator, and subsequently the municipality goes into election, that in fact it's got less to do with the terms of office of political office bearers more than it has to do with the overall performance of the municipality, which is a continuum from one term to the other. Government has to perform and operate in a particular way, which I think ultimately the question of professionalization of the government administration becomes important, that on its own accord, it will have to be judged in terms of its performance based on how efficient and how effective it is, whether from this term or the next administration, it still needs to satisfy the basic expected level of performance as monitored by the upper structure, so that we can intervene, improve, whether in between their election it should be neither here nor there, but the performance must be to the satisfaction of the monitoring sphere, to say that no, at this point they're fine, they need to proceed, irrespective of the fact that they've actually have to move from one term of elected councillors or not. So I think we would all be saying the aspect on the white paper that's focusing on the professionalization of the municipal administration to be very, very important, and that the performance of the administration, municipal administration, becomes important, irrespective of the conduct of the political office bearers in place, and vice versa. As we have said, the competence of the office of the administrative or the senior management of the municipality always becomes important, and therefore the questions of skills and being held accountable, issues of consequence management, all become relevant right across. And we hope that this whole discussion, particularly the new bill, will help us to be able to get to that point where we can have a system that is understood and accepted right across without being questioned from one municipality to the other. We'll have a legislation that will be understood and have no differences in interpretation from one municipality to another. And therefore, when it comes to what form of intervention, whether it's one province or another, the intervention must be roughly guided by the same principles, and therefore there's no sense of arbitrary interpretation, arbitrary intervention from one municipality to the other. If we can refine that, and I think that IMC bill would have been helpful at that level. With all of those comments, colleagues, let's say thank you very much to the department, Dr. Naidu and your team. Thanks to SALGA, and thanks for this whole conversation, honorable members. I hope we can take it forward from here when we process the MC bill. And thanks to those colleagues from provinces who joined us on this discussion. Certainly, we just wanted you to be part of this conversation because we see that this is a matter that has always arisen as a source of debate at SALGA, at NCOP, at different levels, going to courts and all of that. And we need to narrow that so that we spend all our time focusing on improving service delivery rather than quibbling amongst ourselves as to whose powers and whose intervention is acceptable and is not acceptable. Thank you very much, colleagues. May I therefore say the members of SALGA and the members of the department are excused at this point. We will remain with the members of the Parliamentary Portfolio Committee as you withdraw. Shireen, could you get back our agenda onto the screen? Thank you very much, honorable members. The members from the various provinces, you are excused. Thank you.
Thank you, Chair.
Thank you very much, Honorable Chairperson.
Thank you. Thank you. Thank you.
Bye.
Thank you. Thank you very much. Have a lovely day. Honorable Buthelezi, I assume that's your legacy hand. Thank you.
I brought it down. Thank you.
No, that's fine. You are welcome. Can we then proceed now to look at the agenda? That was the last item, really, from the agenda. Shireen, we haven't looked at what we're going to be doing next. Can we share some of that at this point?
Thank you, Chairperson. Yes, for next week, we have on the program again the APPs of the department and the entities, seeing that the budget will be tabled tomorrow. So we haven't finalized anything on our report. We said if there is changes, we will discuss that, and then we will put that into the report. So for next week, we will look at the changes. I know I spoke to SALGA. They said they don't have any changes to their report, so they won't be having anything to discuss with us, but we're not too sure about the departments, if there's any changes in the APPs of the department. Thank you, Chairperson. I'm going to try and just put on the draft program again.
Okay, the other issue would be, have we got any confirmation from the House Chairperson and the Auditor General for the presentation, which was due next week?
Chairperson, we did get permission from the House Chairperson to meet on Wednesday afternoon. I know the Auditor General's office was still speaking to the Select Committee as well. But from the Portfolio Committee side, we did get permission to meet on Wednesday in the afternoon. Thank you, Chair.
Okay, and that's fine then. Before Honorable Mkhalipi leaves this podium, do you want to address her favorite subject?
Chairperson, we did send communication to international relations, to DIRCO, informing them that we won't be able to make the 20th June. So they are looking at dates for us that we can consider for the study tour later in the year. Thank you, Chair.
Thank you. Is Honorable Mkhalipi wanting to come in on that point? Or is she already awarded? Are you still around, Honorable Mkhalipi? Looks like you are absent now. Okay.
Can I just quickly confirm Wednesday, next week, Wednesday's PC will then be from 2 o'clock. Am I right? The one that we've got permission from the House Chair.
Yes, we will give you the formal notification.
Okay.
That's why I wanted to get a clear sense of the AG, because if they are dealing with the cabinet, they may be delayed. It might be up until 1, and then just to move straight from there to us might be a bit tricky. So we will see how it works out for them. But that would be afternoon.
Okay.
Yeah. But look, from where I sit, that's another meeting. Now, that shouldn't really do away with the Tuesday meeting. So let's look at a proper program Shirin's going to show us, so we can all agree on the approach. But this would have been an additional requested time slot because of the convenience to the Auditor General's office. So we'll have this program and then we'll send it through to the members. Any other comments, colleagues? We have dealt with the issue of the study tour, and then we will send to the members the program, draft program. Then we see how things are going to go next week. Can we leave it at that, colleagues? Thank you very much.
Thank you, Chair.
In which case,
Thank you, Chair. We can leave it at that.
thank you very much. In which case, then we then conclude the business of the day, and I want to declare this meeting adjourned. Meeting adjourned. Thank you very much, honorable members.
Thank you, bye.
Thank you, Chair.
Thank
Yeah,
you.
towards Akabaze.
Thank you, Chair.
Thank you very much, Sampa. Thank you, Nyambosa. Thank you, honorable members. Cheers. Thank you.